Hello, I'm Tessa Shepperson and I'm delighted to have with my guest today Robert Brown, who is a housing barrister from Selbourne Chambers in London. But Robert, what interested you in the law and why did you decide to train to be a barrister?
Well, I first thought about being a barrister many years ago, back in my sort of teenage years actually. And then as often happens, sort of life gets in the way and I did a few other things. So I ended up working for the civil service for a bit, for a university and for a charity. But also what I did was I did a few years working for a local authority. Mm-hmm. And a lot of the work that I was doing for the local authority was to do with things around housing and homelessness and connected issues. And that's what really got me interested back into the law, and particularly into the housing side of the law. And then once I started exploring it, I realised it was really quite a big world of housing.
Yeah, there's a lot of it, isn't there? Yeah. So, so where'd you go? So you did your bar finals, did you? And how did you go from there? And
yes, so I did my bar finals. I then did a year after those working for a charity, actually dealing particularly with discrimination, human rights legislation. Then I did pupillage, which is barrister's training at Selbourne Chambers, which is a specialist housing law set. Kept on after that, that was a good experience, a pupillage experience. Went to the Supreme Court with other members a couple of times, particularly on a very big human rights and housing case. And then from then I got kept on, and sort of since then I've been, well, a lot of my work is in the county court. That's the bulk of it.
What sort of cases do you do in the county court? Do you mostly act for landlords or social landlords? What's the sort of balance of your work?
I would say that on balance I probably do work more for landlords than not, but there's no real plan to that. That's just the way it sort of works. And I do a fair amount of work for social landlords, but also private landlords. And I do quite a lot that's not in the county court, but it's in the tribunals, particularly about leasehold properties, service charges, those sort of things. And then in addition to that, I do some homelessness work and that sort of thing, which is usually for local authorities. And do other bits of sort of public administrative law.
So what would that be then?
So it's things that can actually sort of cross over into the housing sphere, but it's things about the control of administrative and governmental power. Quite a hot topic lately, yes. I suppose, in terms of how that is used by the executive and how the courts can put a control on it. It goes to very fundamental issues about what sort of democracy we are, but also, apart from that abstract philosophical level, it can have real impact just on day-to-day for people. And I find that quite interesting, that it ties in a scholarly interest in the law, but also something about making a difference on the ground, as it were. So I do quite enjoy that.
Can you tell us a bit about one of your cases then? Are there any cases that you can talk about that you've done that were in that field? Because it sounds quite interesting.
Well, one of the cases I did quite recently that was in the Supreme Court was a case about homelessness. Mm-hmm. And the extent of the duties a local authority owe to a person depends on, are they actually homeless? Mm-hmm. The statutory test for that. Are they in priority need, which is a question of vulnerability and circumstances? Are they eligible for assistance, which is primarily about immigration status? And then whether or not they became intentionally homeless.
Yes.
Now, no one becomes homeless intentionally. There's a sort of deeming provision that the homelessness legislation has had going back to 1977, the first homelessness legislation. And one of the very early cases under that legislation was about being intentionally homeless. A case called Dinn and Wandsworth. And that, everybody thought, set the law down for years to come. And we were in a case in the Supreme Court that was sort of seeing, did that decision from the 1980s under the 1977 law, did it still apply to the current law, which is under the 1996 Act? And if it did, should it be modified in any way? And lots coming in about what Parliament means when it says something and how you approach legislation. Mm-hmm. These quite high-level concepts. But also, at the heart of it, it was about a mother who now had 2 children and where they were going to live.
Yeah.
Now, in that case, I was acting for the big bad local authority, as it were, who were trying to say, well, we had no duty. But actually, it was more of a test case as to how this is going to apply.
Oh, fascinating. So, so you do those sort of cases. What sort of things do you do in the county court then? What sort of, do you do possession cases? Or?
So a lot of it will be possession cases, both bringing and defending, and then issues that can arise from those sort of things, and then trials on a whole host of issues, sometimes disrepair, sometimes antisocial behaviour. What does a tenancy agreement actually mean? And then the work in the county court can, particularly where it's about leasehold, it can often then end up going to the tribunal to deal with the service charges. And not just the service charges, but other things about the lease. So a fair amount of time in the tribunal as well.
Is it an interesting life?
Yes, I think it is for the most part. It's no 2 days, or 2 days are rarely the same. And I get the opportunity as well, because a lot of what I'm doing when I try and do advice and things like that, and I try to do a bit of training and a bit of writing, and a lot of that actually is about trying to keep people out of court. Trying to find ways to avoid people needing to instruct me to go along and go to court and bail them out of a sticky situation, as it were. So one of the writing projects that I do is I'm an editor of the Housing Law Reports, where we take the most important appeal decisions in housing cases and they get published as a series where we do a little head note explaining what they are. And those are important for a couple of reasons. One, because they are statements of what the law is. Two, they're actually illustrations of where things have gone wrong. And I often think you can learn a lot from someone else's mistake and making sure you're not in the same position. Recently, we're just putting the finishing touches on a book called Quiet Enjoyment, which is about unlawful eviction and rogue landlords.
It's a very famous book in the field, yes.
Well, so this hopefully is going to give it a slight new impetus, because what Parliament's been doing over the last couple of years is trying to legislate far more for what they call rogue landlords, and we're going to have systems coming in of banning orders. We're going to ban people from being able to be landlords. Also, rent repayment orders are going to be extended in the circumstances in which they're available. So it's really there as two purposes, I suppose. One, so that tenants know what their rights are. Two, also so landlords don't inadvertently fall into some of these traps, because you can have the rogue landlords who are just out for a quick buck and don't care, and there are some. But also I think you can have quite genuine, well-meaning landlords who don't realise what they've got themselves in for. And I think it's very important that they know and understand as much of the law as possible, because there is a lot of it that applies, and you can very easily, without meaning to, fall foul of it. But ignorance of the law actually sometimes can be a defence. But the general proposition, yes, is that ignorance of the law is no defence. So it's to try and inform people and help them, and that's why we do some of the training together, and I hope that's helpful for landlords and managing agents, and so just try and find a way to navigate through the minefield, particularly for those who don't want to do things wrong, just sometimes find they might be falling foul of these ever-changing, complex provisions, both from Parliament and then from central government, local government, the courts. It's never stays still.
It's always changing, and of course local authorities are getting new powers of enforcement.
Absolutely.
Which means, I suppose it's particularly more important for landlords and agents to understand things, because they're going to be enforced more rigorously, I think.
Absolutely. There are new criminal offences that are coming online, but also there is going to be a power for local authorities, particularly enforcement authorities, A, to go and get rent repayment orders, but B, also to serve civil penalty notices.
Yeah,
and I think they're going to be using, for up to £30,000, I think they're going to be using them a lot, partly because there's a difference in where the money goes.
They keep the money. So
that's going to be very important to them. It's going to be slightly easier. It's going to be a bit of a sell, I think, to the landlord to say, well, you might not like it, but if you accept this, then we don't need to go down this route and that route and the other, but it may still leave open rent repayment orders. And then there is this whole prospect coming soon of banning orders. Yeah. Which could be, they could really end a landlord's business.
Well, they lose a business, yeah. So serious thing. So it's a serious subject, and it affects a lot of people's lives.
Absolutely, absolutely. There is little more fundamental and basic to human existence, barring food and water,
than someone's home.
Than shelter.
Yeah.
Absolutely. It is one of the key concepts of our society.
So it's an interesting area to work in.
It's an interesting area to work in, but it has its perks, and it can be enjoyable for all the serious side.
Yes, so thank you, Robert, for coming and talking to us and explaining your professional life.
Thank you, Tessa. It's been a pleasure.
Thank you.